Folks, thanks for coming up. To my great surprise, we're already after the lunch hour. Just a word about that. Judge Fererra is taking this very, very, very seriously. If you argue a case in front of the United States Supreme Court, you get 15 minutes, and the other side gets 15 minutes, and then you're done. That's kind of the schedule. I've argued a lot of motions in front of Superior Court, and usually it's 10 aside, maybe 15 aside. If you got a couple things going like we did today, you get 20 aside. I'm sure everybody noticed we were in there for 3.5 hours. That's really extraordinarily generous with the court's time. Every Superior Court in the state has a heck of a lot of stuff in front of them, things that are very important for the litigants. And for a Superior Court judge to basically turn the clock off and let argument from counsel go for 3.5 solid hours with very insightful, very probing questions, tough questions on all sides. That's heartening, that's encouraging for people who are interested in this and concerned by it and watching it. I think you saw that you've got a judge here in Chelan County. You can tell I'm doing 2 of these lawsuits, right? Although, in my defense, the Attorney General said Douglas County about 20 times before I started saying Douglas County. So, no, you have a great judge who's given very serious thought to the issues here, and I'm heartened by the time and attention that she gave to this, and you all should be as well. Obviously, we're all hoping for a decision, a favorable decision soon, but it's entirely appropriate for her to say, look, this is a lot of stuff. There's a lot of papers here. They've been filed in a hurry. She asked for more things from me that we're going to provide. Obviously, she's going to look at that. She wouldn't ask for it if she wasn't going to look at it. And so, although we're tired of the delay, she's really taken this case very seriously, and I really appreciate how much time she gave us to argue it. On the other hand, it's kind of like running a triathlon, and I wasn't ready for that today, so I'm kind of exhausted. Just briefly, in terms of what the 2 issues are, I'm sure it's pretty clear to everybody. The first one is just, where do we have this case? Is the case going forward in Chelan County with Chelan County plaintiffs, or can the governor, whenever he wants, say, gee, if you want to sue me, you got to sue me on Olympia? There's certainly plenty of times when people have sued the governor, and the governor's perfectly happy to let those cases be heard in local counties. The Attorney General has decided that the governor basically gets to pick. I think he's wrong. I think that's not what the statute means. That was kind of the second argument. And I appreciate that the court gave us a ton of time to argue the merits first. Obviously, the merits here are not that there's never an emergency, not that there's not a problem, not that COVID-19 is nothing at all, but that emergencies come and emergencies go, and when the emergency stops, the governor can't keep saying it's an emergency, and it's not an emergency simply because the governor says it's an emergency. And really the underlying point there, and the reason we keep pointing to Chelan Douglas County Health District and the other local health districts and these flu pandemic statutes is the way government works in Washington and in every state in the Union and in the United States is that the rules that govern your conduct on a day-to-day basis are made in an organized fashion, usually by the legislature. And remember that. Remember how a bill becomes a law? I love that little one. How does a bill become law? The legislature passes it. They vote on it in both houses. They amend it. They talk about it. There's lots of discussion. And then they hand it to the governor. The governor signs it. Now that's a law, and it stays a law forever until it's amended or repealed. And that's what governs our conduct. And that's not how we're living right now. Right now, the rules and regulations governing your conduct and mine are things that the governor decided last night and will announce in a press conference this afternoon. That's not how we make law. That's one thing in an emergency, in a real genuine emergency, when the tidal wave is headed for Grace Harbor and he says, I can't call the legislature into special session, we're just going to make both lanes of the highway eastbound and everybody get out of it. Totally legitimate. But once the tidal wave recedes, the emergency's passed, you got to drop the reins and hand it back, in this case, to local authority. To local authority in this case because that's what the statute says, that's what the legislature decided, that's the instruction we have written into the revised Code of Washington. And so, the question is not, are the things the governor is doing a good idea? Are they a bad idea? Do I agree with them? Do I disagree with them? Do I have better experts than they have? That's not the question. The question is, who has the authority to instruct you what you're supposed to do. The legislature gave that authority to the Chelan-Douglas County Health District for people in Chelan and Douglas counties. The governor took that authority when the threat to the state was so large that it superseded anything we planned for, anything we had in statute, anything any local organization could do. Once that threat abates, you can't keep holding on. So that's our case. I'm very heartened by a lot of the questions that the judge asked. I will say the theory we have is that they're actually not relevant. Like either it's in the hands of Chelan-Douglas County or it's not, and who's doing what and which and where doesn't really resolve the question of the legal question of whose job is it. But she had some very good points, right? Why aren't we at phase 2 here? Well, we keep having positive cases. Well, why do we have positive cases? Well, the Attorney General's guy had to kind of wave his hands about that. Testing's important everywhere. We're trying to increase testing capacity all over the place. So it's, well, who did the testing capacity here? Right? You guys did it. Stamilk did it. They're looking out for their workers. They're testing as much as they can. They know there's the, potential for negative outcomes there, and so they're being super proactive. It's the kind of thing you want an employer to do. It's the kind of thing you guys would be happy to do if you were employing people and have those resources available to you. Maybe you are employing people and are getting ready to do that for your workers when they come back to work, right? It's exactly what we want people to do. Look out for each other, try to find out, is somebody infected and we don't know it, and what do we do with that? And then we treat them, we isolate them, we take them to a hospital system that's perfectly competent to take care of them. And again, strictly speaking, legally irrelevant, but the judge is onto something there. Why does Chelan County appear to have so many high numbers of cases? Because you've got a great employer in Chelan County who's being super proactive about protecting their workers. That shouldn't be something that comes back to bite the rest of the county in the butt. That's what's supposed to be happening. People taking care of each other, looking out for each other, making sure that people stay healthy and people who aren't healthy get the treatment they need. That's not a reason to say, ooh, Chelan County's now the second worst in the state for positive cases. Chelan County's the best in the state for testing people and looking out for each other's health. That's what that means. You're not the second worst in the state, you're the best in the state. You're out there testing, you're out there looking out for each other. So, again, strictly speaking, is that legally relevant to whether the governor should be in charge or the Chelan County Health District should be in charge? No, it's just a matter of reading the statute. But as a practical matter, come on, tell me. The governor's got a program in place that has horrible disincentives. Chelan County and Douglas County Combined Health District don't, right? They're not going to put a program in place that says if you dare to test your workers or test your employees and try to find out if somebody needs medical attention, then we'll shut you down. Then nobody would be testing. We wouldn't find out who needs help and assistance. That's a bad idea. It is actually the governor's program, and it's obviously a really bad idea. Again, strictly speaking, as a matter of law, my question is not whether my ideas are better than the governor's ideas. It's that it's past time for the governor's ideas to matter, and it's time for the legislature's ideas to matter, and those are the ideas they passed in a statute 14 years ago. So, nonetheless, it was very heartening to me to see that the judge is well aware of the distinctions between these two statutes and the kind of authority that the flu pandemic preparedness and response statute gives to local health authorities. It's the kind of authority that is specifically geared to this kind of problem, and is specifically geared to local officials who know their local area dealing with the problem as it arises here. The mere fact that people all over the world get this disease doesn't mean we should have a worldwide response. I hope the governor's not ginning up the idea that he ought to respond to COVID-19 in Washington State the way he would if he were ruling Brazil, right? It's really bad in Brazil. And the legislature's already told him he doesn't get to respond to this on a statewide emergency basis. The legislature says your local health authority is the response. If it gets to the point where the local health authority can't handle it, you know what? Their pandemic flu response plan already has in place a way to call on resources from the state and call on additional resources. So it's not like nobody ever thought this might happen and we have no idea what to do. We've been planning for it for 14 years. Here it is. Let's execute the plan. I think it's all I have on kind of questions until my voice runs out. So.
How do you feel about where the case is at right now?
I'm happy. I'm happy about it. I'm happy about the argument. I think the judge is certainly in the questions, I think, very, very clear on the distinction that we're drawing between things that are and were legitimate emergencies and legitimate basis for exercising that emergency authority. And I think the Attorney General was working very hard to distract from that and claim that I personally, and the experts I bring forward, have to have a better idea about how to deal with COVID to show that the governor's not doing a good job of it. And again, our claim is not whether or not he's doing a good job, it's that it's not his job to do. And I think the judge was very clear on that. I think a lot of the Attorney General's argument on the merits really went to the question of whether or not the governor's ideas are good ideas or not. You know, and that's like asking your dentist whether he's really very good at collecting the garbage up and down your street. It's not his job. Maybe he's got a better idea, but if he wants that job, go work for a waste disposal company and stop being a dentist. I'm not saying the governor's necessarily bad at what he does at governing. I'll leave that to others to decide, but this just isn't his job anymore. And I think she's pretty clear that at the very least she knows perfectly well that that's the argument we're presenting, and so therefore a lot of what the Attorney General had to say about that is if she agrees with the way I'm presenting the case, most of what he said is irrelevant.
So it seems like a lot of the energy today was dispensed from the state side of the equation to have the hearing moved rather than dealing with the actual merits of the case. Why, for those of us that aren't familiar with you, why so much effort to move it and just not have the case heard here and ruled here?
I think a hometown advantage. I think the reason you would want to move a case is to get to a judge who you think will rule the way you want the ruling to go. And so the idea that a bunch of different cases in different counties with different plaintiffs facing different legal regimes and suffering different individual local harm ought to all be consolidated in Thurston, because after all, you guys can watch the hearings on Zoom. It is just not appropriate, and I think it really is just for tactical advantage. It's just for tactical advantage. And so there's obviously been a lot of effort put into that. It's not something that the state routinely does. The water rights case came up out of Bellingham area, if I recall correctly. So north end of the state did not say, oh, wait a second, whether or not anyone can drill a well in the state is a statewide issue, and this has to be heard in Thurston County. The McCleary case was heard in King County. The state did not say, oh, no. I mean, this is going to affect how we fund schools across the entire state. This case has to be heard in Thurston County. There's lots and lots of cases that are filed in superior courts around the state where local judges decide issues that they know perfectly well will eventually have statewide implication. That's not unusual at all, and it's very normal for the state to litigate those cases where they're originally filed. Frankly, I was surprised and disappointed to see the Attorney General do this. Even if the governor is allowed to pick Thurston County as home base and where those cases are heard, and I don't think he's allowed to pick that, he doesn't have to. Venue is a party's privilege. It's not a right. It's not an obligation. It doesn't mean the court can't hear a case. If you say, I'm willing to go to that court and have the case heard there, it doesn't matter whether you have the right to move it. So the governor could, in fact, simply elect to say, I don't think this is the right place to have it heard, but I don't mind. I'm happy to come here and have the case heard here. And to my mind, that would be the appropriate thing for a governor of an entire state to say when local citizens of the state say, we disagree with your actions, we think your actions are harming us, you're harming us here in our homes, and we'd like that case to be heard here where we live in front of judges in our community who we elect. say, tough, I live in Olympia, my pen is in Olympia, and so you guys should march out to Olympia to have your claims heard. I don't think he's entitled to it, but even if he's entitled to it, it wasn't something they needed to say. And it, I think it's a motion they ought to drop.
So you think she would make a new case law if she granted that?
In the sense that you may have caught this, there aren't any cases on that. So that venue statute has very, very, very few cases, and nobody's found a case where a lawsuit against the state as a whole or against the governor's official capacity, which is effectively the same claim, was moved to Thurston County on the grounds that it's required to be moved. That statute's been on the books for a long, long, long time, and the Supreme Court has never said either that's what it means or that's not what it means. So in that sense, it would be making some new law, but I think it also really tees up the point that the governor doesn't do this. Whether it's because they just dreamed this idea up for the first time for these cases, which I think is actually true, it's really a bad theory. It's a bad theory. It was made up to try to get these cases consolidated in Thurston. I don't think it's happened before because I don't think anybody else reading that statute said, ooh, this means we can demand that the cases get moved to Thurston. I don't think anybody's thought that before because it's not what the statute says. But even if anybody had that idea before, it's the lack of any cases on it mean that they haven't done it. And so, in that sense, the Attorney General and the Governor are forcing the judge to make some new law by taking steps that are really novel and something that hasn't been done before.
It's a unique situation for you to be working pro bono for the citizens of our county. It's an exceptional amount of work culminating in weeks and weeks and weeks of study. Where is your passion coming from for the plaintiffs involved, for the legality of the case? Is it a purely lawful thing? Is it a humanity thing? Where is your passion for this case coming from?
Very much both of those. I started looking into this stuff and working with some folks in Olympia back in late March and early April, hoping that we could see a lot of the emerging data and a lot of the emerging good news, frankly, about COVID. We've been learning for months now where the locus of the harm is, how we need to go about protecting people. I was really, I don't know, really hopeful. I was sort of hopeful that come the end of April, these proclamations would, in fact, be lifted because there was so much good news about, lower illness rates, lower hospitalization rates, lower ICU use. There was just so much good news coming out from what we initially feared, that doctors had figured out treatment protocols, we had hospital beds available, and at the same time we were already seeing some of the bad news of hospital staff having their hours cut, obviously everybody else as well, but even just within the healthcare system, we were seeing significant challenges to the viability of the healthcare system, and particularly in Eastern Washington, I think Southeastern maybe the most, because of the ban on elective procedures. So I was hopeful, at least a little bit, that we would not be in a position in May that was supposedly exactly like the position we were in March. Unfortunately, that's where we are. Professor DeWolf and I have done a lot of state constitutional law claims like this. We are kind of law nerds. We do like those kind of claims. But bringing that here in Chelan and Douglas on behalf of the folks here has just been just wonderful, just hugely important to me to see how seriously it's being taken here, to see how much local officials have stepped forward and said, not only do we think you're right about the law, but we really want the reins. We are here, we are ready. We were elected and appointed and employed to do this job in Chelan and Douglas County, and by golly, we want to do it. That I think is just, it's huge to see provide support. And then, of course, the very many plaintiffs we have in this case, and so many others who, for a variety of reasons, decline to be plaintiffs but have spoken to me about the case. It's a fantastic community. It's a fantastic group of people. It's really painful to see a lot of the harm that's being inflicted in the community, and the complete lack of recognition by the governor that he's doing a lot more harm than good. You guys, you did what needed to be done. The hospitals are ready. The community's ready. The health district's ready. People know what they need to do to keep themselves safe and their neighbors safe. They're doing great stuff, right? All that testing the judge remarked on. It's exactly what needs to be done. And the idea that the governor is just absolutely turning a blind eye to the kind of suffering imposed on this community, and justifying that he's continuing to do that on the basis of data that reflects how much this community cares about its fellow citizens and its neighbors is just, it's just awful. It's just awful that he would have the gall to say, you guys stay in phase one because you're working too hard on keeping your community safe. So, little bit of both, Josh.
If it was kicked loose from the state control, that it would be, just willy-nilly, and, that things would just open up and nobody would be safe. And I just thought you did I'm more making a statement than a question, but I thought you did a great job of articulating that, no, there's a plan in place. Did you have that impression that they were trying to imply that at several times?
Yeah, and the other one, the suggestion that, and again, this is part of his focus on, do I think what the governor's doing is a good idea or not? Is that what I'm suing about? Did I bring in enough experts? Brought in 0 experts, right? That's why I said, look at the governor's experts. That's what you need to look at. They tell you who's supposed to be in charge here. Look at what the experts say, look at the statute, and now you know who's supposed to be in charge. At one point, he also suggested, gee, what you're really asking is for the court to decide what kind of safety measures need to be in place. Should the court be micromanaging pandemic flu response? And of course, that's not true either. The courts in every county have a vital role to play, and Judge Fererra is taking very seriously that role. But it's not her role to run the Chelan County Health Authority. There's some other folks in the county who do that, and they do a great job of it. So again, we're not asking for the court to micromanage what the response should be. We're not asking for the governor to micromanage what the response should be. We're not claiming that the governor's response is the best, the worst, or somewhere in between. We're just saying it's time for him to drop the reins because it's not an emergency, and the response comes pursuant to state law from local authorities.
She was saying there was some key documentation that she wanted to kind of get validated that we have outstanding that really decide everything. Taking into account what exactly are some of the things?
So when we filed Friday, it was kind of a frantic scrum, pulling everything together. Some of the documents we put in are sort of official state records, so statements on official public entity letterhead. I think those are appropriate. It's a thing called judicial notice. Can a court just take notice of certain facts? So like the COVID dashboard, right? It's getting updated all the time. If I want her to know what the COVID dashboard looked like 5 weeks ago, I need to do like Wayback Machine or have it printed out 5 weeks ago and have a certification. This is really what it was 5 weeks ago. On the other hand, it's Department of Health official stuff. She can go pull up the COVID dashboard right now and look at it and take what's called judicial notice of what the data is on there. It was my view that some of the statements we put in were similar to that she could take judicial notice of it. She's a little concerned about them being just sort of a statement on official letterhead. I understand that concern. We're addressing it by making it a little more court official instead of public entity official. So that's some of the stuff that we're putting together this afternoon and getting in. Legitimate concern of the court, and we'll address it right away. touch. I appreciate you guys aren't going to keep me up